Hi, this is Lee from the Law School Toolbox. Welcome back to the Listen and Learn series. This is part one of a two-part Listen and Learn series on 3 commonly tested excuses for non-performance of a contract: impossibility, impracticability, and frustration of purpose. In part 2, we will apply this law to fact patterns. Today, we are going to be talking about 3 commonly tested excuses for non-performance of a contract: impossibility, impracticability, and frustration of purpose. Unlike defenses to formation such as mistake or unconscionability, a party asserting an excuse is not claiming that they are not contractually obligated to perform. Rather, they are claiming that their contractual obligations should be discharged as a result of supervening events that occurred after the formation of a contract. So let's review the rules for these excuses, starting with impossibility. Performance is discharged when it is objectively impossible to perform a contract because of 1. Death or physical incapacity of the person necessary to effectuate the contract. 2. Unanticipated destruction of the subject matter necessary to fulfill the contract. Or 3. A new law or regulation that was unanticipated makes performance extremely and unreasonably difficult or expensive. To illustrate, let's look at the landmark 1863 English case of Taylor versus Caldwell. As you may recall, in Taylor, the plaintiffs contracted with the defendants to use a music hall for concerts and other events over the course of 4 days. A week before the first concert, through no fault of either party, the hall was destroyed by fire. The court held that because the fire was not the fault of either party, and the destruction of the hall rendered it impossible for the plaintiffs to utilize the venue as intended, the parties were excused from performing their respective duties. Okay, let's move on to impracticability. Performance is discharged as impracticable when 1. An event occurs after contract formation, 2. That is unanticipated by both parties at contract formation, 3. Making performance extremely and unreasonably difficult or expensive. This doctrine is interpreted narrowly by the courts. Generally, an increased cost to perform a contractual obligation is not sufficient to render the contract excused due to impracticability. In the words of the restatement, a mere change in the degree of difficulty or expense due to such causes as increased wages, prices of raw materials, or costs of construction, unless well beyond the normal range, does not amount to impracticability, since it is this sort of risk that a fixed-price contract is intended to cover. The case law on this issue, while not always consistent, makes clear that mere increased cost, lack of profitability, or even financial loss does not by itself rise to the level of impracticability. For example, in the government contracting context, courts have held that increases in costs of 57% and 70% did not by themselves constitute commercial impracticability. In contrast, courts have found performance to be impracticable when compliance with the contract would entail an extreme increase in cost coupled with an extreme increase in the difficulty of performance. For example, in one case, performance was held to be impracticable, where it would have taken more than 8 times longer and cost more than 20 times more than originally anticipated. In another case, performance was held impracticable, where it would have taken almost 7 times longer and about 150% more than anticipated. You likely did not cover these cases in law school, and you don't need to be familiar with them to analyze an impracticability case. The important thing is that you understand that, generally speaking, performance is not impracticable merely because a party will have to spend more money. Before we move on, it's worth quickly noting that the terminology here is not always consistent. For example, the restatement substitutes impossibility with impracticability. In other words, under the restatement view, physical impossibility is considered a type of impracticability. And that might be the way you learned it in law school. If that's the case, you should write your rule statements accordingly. But for the purpose of our discussion today, we will be treating impossibility and impracticability as separate concepts. You should also treat them as separate concepts on the bar exam. Okay, now that we've cleared that up, let's move on to frustration of purpose. The frustration of purpose doctrine discharges performance under a contract if the purpose of the contract no longer exists. Performance is excused if 1. A party's principal purpose is substantially frustrated without his fault, 2. By an unforeseeable supervening event outside the party's control, and 3. Both parties knew the purpose at the time of formation. To illustrate, let's go back to England for the case of Krell versus Henry. You may recall Henry entered into an agreement with Krell to use Krell's flat for 2 days to watch the king's coronation. Henry approached Krell about the flat in response to a flyer hanging in Krell's window announcing the availability of the flat for rent to see the coronation. The written agreement, however, did not mention the coronation or any other purpose for the rental. When the king became ill, the coronation was canceled, and Henry refused to pay for the flat. The court held that Henry's performance was excused because the contract was implicitly founded on the assumption that the coronation would take place. In other words, without the coronation taking place, the contract was essentially valueless to Henry. It's important to note that frustration of purpose is a very narrow excuse that is invoked successfully even less frequently than impracticability. As with impracticability, frustration of purpose cannot be invoked merely because a contract is no longer profitable. Thanks for watching part 1 of this 2-part series. Please continue to check out part 2, where we will apply this law to fact patterns. And be sure to like, subscribe, and leave us a comment letting us know what content you would find helpful.